Maritime Law Newsletter, an annual summary of key Canadian legal developments. 2018 was another active year in Canadian maritime law. The federal government Ocean Protection Plan (OPP) has continued to spur legislative, regulatory, and policy change in a number of areas, ranging from the proposed Wrecked, Abandoned, or Hazardous Vessel Act to the proposed Oil Tanker Moratorium Act to various regulation and policy initiatives aimed at protecting marine wildlife. Numerous important legal decisions concerning maritime law and related admiralty practice areas were also rendered in 2018. Additionally, the legalization of recreational use cannabis in Canada has created multiple new obligations at all levels of the maritime industry. Policy Development Pilotage Act Review. The government review of the Pilotage Act RSC 1985 P14 was completed in spring 2018. The Pilotage Act was originally enacted in 1972. Following the Royal Commission on Pilotage, the Pilotage Act provides the legislative framework for pilotage services in Canada and establishes the four pilotage authorities as Crown Corporation: the Atlantic Pilotage Authority, the Great Lakes Pilotage Authority, the Laurentian Pilotage Authority, and the Pacific Pilotage Authority. The Pilotage Act has been reviewed several times since its inception, either as a standalone subject or as part of a wider review of transportation issues. Although there have been several recommendations for reform, there was only one set of substantial amendments made in 1998. Otherwise, the majority of the Pilotage Act is largely unchanged. According to the Government of Canada, the primary purpose of the current Pilotage Act review is to modernize the legislation to better align with the existing and future realities of the marine transportation system. The final report makes 38 recommendations categorized under the themes of purpose and principles, governance, labor, safety framework, tariff and fees, and technical amendment. Highlight of the report include recommendation that the Pilotage Act be amended to include the following: a preamble setting out the rationale for legislative action and the linkage to the broader public interest, including environmental protection. A proposed clause that clearly outlines the government legislative purpose of establishing a safe, efficient, responsive, and accountable national system of marine pilotage as a regulated monopoly, as well as outline the public outcome the legislation is meant to secure, and a statement of governing policy principle for the national marine pilotage system. The government make a commitment to developing and implementing a code of conduct for all licensed marine pilots. The Great Lake Pilotage Authority and the Laurentian Pilotage Authority be amalgamated into the Laurentian and Great Lakes Pilotage Authority. One position of the Board of Directors of the Pacific Pilotage Authority be reserved for a representative from the indigenous community of British Columbia. The final over-selection process be amended so the arbitrator must consider the purpose and principles of the Pilotage Act when making arbitration ruling. The Pilotage Act be amended so all pilot corporations as monopoly service providers be subject to greater levels of transparency and accountability. The Pilotage Act be amended to provide the Minister of Transport, with the approval of the Governor-in-Council, the authority to make all regulation pertaining to pilotage safety, and that the Pilotage Act and its regulation have primacy over pilotage services contract. The Pilotage Act be amended to provide the pilotage authorities with the authority to adopt and enforce binding practices and procedures related to the safe and efficient delivery of pilotage services. Transport Canada, as to the independent regulator, established a comprehensive set of key safety performance indicators. The government provides the necessary resources to develop the pilotage safety regulatory and oversight capacity in Transport Canada. The Pilotage Act enforcement provision be amended to include an administrative monetary penalty scheme that imposes higher penalties for serious violation. The Pilotage Act be amended to provide the Minister of Transport with the authority to regulate the conduct of pilotage risk assessment. The Pilotage Act be amended to establish an objective that pilotage authorities must optimize the use of new technologies. The Pilotage Act be amended to provide the Minister of Transport with the authority to require the pilotage authorities to publish their voyage plan and that the Minister of Transport exercise this authority. The Minister of Transport pursued an amendment to subsection 22.2 of the Pilotage Act to extend eligibility to all foreign master and navigation officers for a pilotage certificate and subsequently terminate the Pacific Pilotage Authority waiver program and replace it with pilotage certification. Transport Canada implement and administer a standardized exemption scheme and stipulate the requirement in a new national regulation. Transport Canada amend the general fitness requirement in the General Pilotage Regulation SOR 2132 and undertake a review of the processes for determining medical fitness of pilot. Transport Canada amend the Marine Personnel Regulation to formally recognize crew experience, training, and qualification required under the Polar Code. The Pilotage Act grants the pilotage authorities complete authority to fix tariff and other fees as is the case with NAV Canada and the port authorities. The ground for filing a tariff objection to the Canadian Transportation Agency be limited to compliance by the pilotage authorities with clearly specified statutory criteria, including pilotage authority operational consideration and processes, and only those subject to tariff charge or their representative and association be able to file objection. The Canadian Transportation Agency render decision no later than 90 days after receiving a notice of objection. The pilotage authorities be authorized to fix fees for all other products and services provided by them. Establishment of new Marine Refuge and Parliamentary Committee report on marine protected areas. The Parliamentary Standing Committee on Fisheries and Ocean released its 14th report on the 42nd Parliament, Healthy Ocean, Vibrant Coastal Communities, Strengthening the Ocean Act Marine Protected Areas Establishment Process.